and co-arbitrator with arbitrator appointments under the rules of the ICC, the ICDR, the HKIAC, UNCITRAL, etc. She's among the first 30 emergency arbitrators that were appointed by the ICC, and she has served as an emergency arbitrator for the ICDR and as an appellate arbitrator for the AAA. Prior to becoming an arbitrator, Stephanie was counsel at Weiss and Case in New York, where she was a member of the firm's international arbitration practice. She regularly speaks and writes about arbitration, and she's constantly faculty for arbitration training courses for the ICC, the CPR, the Chartered Institute of Arbitrators, the New York State Bar Association, and the Toronto Commercial Arbitrators Society. She's well known for her work on technology impacting arbitration procedures, and recently chaired the working group on information technology in international arbitration for the ICC Commission on Arbitration and ADR. She's also the author of Early Pandemic Model Procedures for Virtual Hearings, and has written an award-winning article on cybersecurity. In general, Stephanie has broad experience with complex disputes, diverse legal systems, and cases that involve aircraft equipment contracts, audio coding for wireless technology, blockchain and distributed ledger technology, construction delay on power projects, internet marketplace platforms, distribution and wire development technology, among other matters. Clearly, we have an expert independent arbitrator in the room this afternoon, and we're just looking forward to an impactful and exciting knowledge sharing session. Stephanie, good afternoon.
Good afternoon. Thanks for having me.
Oh, by all means. So I'll just go straight into the questions that we want to ask you this afternoon. And I encourage the members of the audience as well to please drop their questions in the comment box as Stephanie basically goes through her presentation this afternoon on Fintech and ODR. Stephanie, it's just to start off the conversation. I've just mentioned, the growth in the fintech space and, the need for an ODR model, but could you briefly explain the concept of ODR just for our listeners?
Absolutely. And I will actually preface by saying that there are some pioneers in the ODR industry who I know are connected with your advisory board. I know is on the call, and I think we might just need to mute somebody's microphone. But I can offer you perspective of someone who hasn't been working in the ODR field. That really folks like Mirez will be able to correct me when I misstep, but I do have experience in dealing with fintech disputes and a really broad interest in technology impacting procedures. So one of the things that intrigued me when I was asked to join you today was the knowledge sharing aspect. I'm certainly very interested in hearing about your regional experiences and perspective. And when I came at this topic, I was sort of also thinking about experiences as someone participating in traditional arbitration mechanisms and what we've learned from that process, and thinking about it in terms of the future of ODR. So I'll go back to your question, but that's sort of an important, I think, caveat given the nature of the topic. So what is ODR? Well, ODR, online dispute resolution, originated in the 1990s. And originally, the focus, I would say, was on using the internet to resolve disputes from start to finish. So a form of online ADR. It could employ any range of dispute resolution processes, complaint boards, negotiation, mediation, facilitated settlement. Very often it's a combination of processes. And the impetus really came from e-commerce, online transactions. So, as e-commerce really started to boom, people started to think, well, why should we be resolving our disputes offline that arise in the e-commerce realm? We should be able to resolve them online. So, as time has evolved, we found applications in other areas, resolving small claims court disputes. So there's a lot of offshoots in court processes or things like traffic tickets or family law disputes like child support, also used for disputes like domain name disputes. Internet marketplaces, eBay, fantastic example of long-term use of online dispute resolution and really in the e-commerce realm. As the field has evolved, and especially coming out of the COVID pandemic, if you look at how people talking about ODR, it's interesting, I think, as the contours start to blend. There are questions from sort of a theoretical perspective at the extent to which hybrid processes where technology is integrated into the more traditional face-to-face mechanisms like virtual hearings, whether that is really something you should be thinking of in terms of being ODR. Traditionally, it wouldn't be. But one of the most interesting, I think, new sort of platforms that's emerged is one out of Asia called EBRAM, Electronic Business Related Arbitration and Mediation Online Dispute Resolution Center. They seem poised to really start to blow up, have a lot of really well-known arbitrators joining their panel. And that really is more of a start to finish electronic resolution that it really sort of incorporates a lot more of the traditional components of arbitration or mediation. So options where you can still move back and forth between processes, but also the ability just to sort of think of having arbitration completely online start to finish. So that's sort of the broad brush on what is ODR and where it is today. Oh, you're on mute.
Thank you. Thank you very much, Stephanie. Like you rightly pointed out, that ODR has come to stay. It's not something that's up for debate, and its usefulness as well, especially given the COVID pandemic and how virtual hearings basically became the mainstay, is also not in doubt. The question that I then want to ask you is there a special need for ODR as far as the fintech industry is concerned?
Well, and I think in that respect, it's useful to sort of think about what is fintech. I mean, we talked about e-commerce at the outset, but we really can kind of go beyond that. So, fintech, traditionally, you use that to refer to the application of new technology to products and services in the financial industry, but also really tends to be centered on specific applications of artificial intelligence, blockchain, cloud computing, and big data. Those are the ABCD, so-called ABCD of fintech. So if we go back to thinking about e-commerce, we can think of applications like payment apps like PayPal or Venmo, where you're using them instead of traditional sort of banking mechanisms. There are investment apps like Robinhood, you might be familiar with, used so that people can trade stocks. There have been a lot of disputes that have come out of Robinhood, but more recently, crypto apps, right? Like cryptocurrency exchanges, cryptocurrency wallet applications. And in fact, the biggest fintech companies in the world are Visa and MasterCard, right? Because they are operating, financial services online. So in terms of what the appeal is of ODR to fintech, it goes back to the sort of reason that I mentioned as the impetus for ODR back in the 1990s, which if we're online, why are we, and we have disputes that arise online, why are we taking their resolution offline? Doesn't that sort of complicate it and make it more difficult? So I think that appeal absolutely still exists. And I think the sort of promise of being able to resolve, faster, cheaper, in a more convenient fashion continues again to be the impetus. What we sort of see now, I think, when we're talking about what kind of disputes are arising in terms of, blockchain applications specifically or cryptocurrency, that's a tougher question. The kinds of disputes that I have seen arise are things like disputes between developers you know, and the sort of the product, if you will. So that ends up getting into software development, collaboration, and the nitty-gritty resolution of those kinds of issues tends to require experts. It also requires more detailed contract questions, like, was it a time and materials contract, or was it a fixed price contract? What was in the scope of work? Those kinds of things are you know, line up with much more traditional kind of dispute questions that you don't necessarily think of as being entirely online, but that's really comes out of fintech. Ownership issues like intellectual property, who really owns the technology, particularly when there's collaboration disputes that pops up, hacking disputes, and frankly, just investor disputes, shareholder disputes. I've seen cases that where, you know, I guess it really sort of arises out of the technology, but the issues that are before the arbitrator are about what representations were made about the technology, fraud disputes. Those kinds of things line up with what traditionally gets resolved in, you know, the cumbersome court procedures and arbitration procedures. So in that instance, is there a special need for ODR in the traditional sense? And I think we'll start to talk about like how it actually works in practice. Much tougher, I think, to resolve those kinds of disputes in the more traditional ODR. If we were talking about the EBRAM model that I mentioned at the outset, where you're really trying to more have an option where you're doing everything online, but you have face-to-face interactions online, if that falls within our definition of ODR, I think there's much more promise for fintech to be resolved that way. But I still think, and we'll get into the, you know, the sort of modes, that negotiation, settlement, mediation, absolutely there's a huge need for those kinds of processes in the fintech industry, because we're often dealing with startups. We're dealing with, you know, financial investments that are tied to a lot of these collaboration agreements that really make speed extra important. So there is, I think, a role, you know, to play for those disputes, but bigger questions about once you get to some of those more difficult, challenging disputes, I think it's hard for me to sort of see, you know, the way in which ODR has developed originally, that sort of being the mechanism for it, but makes sense in the e-commerce kind of market.
Thank you very much, Stephanie. Mr. Gunshaito, I see you have your hand up. Were you looking to make a contribution there, or do you want to wait till the end of the session?
I was going to ask a follow-on question.
Oh, great.
We see a lot of financial apps and sort of banks transitioning from traditional sort of banking in East Africa. And I know we have an East African and Southern African contingent here, where the banks are moving from the traditional banking system to moving completely online and developing apps and technology to move banking onto our phones, which is effectively moving on one step before the metaverse. That's how banking has developed in Africa over the last 15 years. Do you think that the disputes will now not be court-based because they're entirely app and cloud-based? Do you think that most of those banking and financial technology disputes will be ODR going forward?
Well, I mean, we still have, you know, fundamental access issues and infrastructure issues that we need to confront. So the question of, you know, in a market like Africa, where so much of the economy has been tied to people's access to the mobile devices, and there's been tremendous development there, you know, to the extent that there remain stability issues, infrastructure issues, that remains sort of an impediment. But on the other hand, it also kind of speaks to, if you're in a place where you know, people may be located far flung from cities, right? The geographical reach is broad, huge promise to be able to leverage that you know, much more developed mobile wireless technology. So the more that advances are made, to be able to improve that access. And as you said, that's been very strongly developed and continuing to develop in Africa. I think there's great promise for more of those disputes to move online, because frankly, that's sort of, you can see that there's greater ability to access if you're reaching people that way, why convert them to go to a different forum? So it makes real sense to be able to do that.
How far are we away from the technology to do that? At least when you're dealing with the tech people, how far are we from that transition?
I mean, that's a great question, because anytime you're dealing with the development of a new service provider, there's a question of whether you're trying to resolve things on their platform or whether they're agreeing to another platform. And ideally for neutrality, right, you're going to want to have it in somebody else's platform. But take an example like eBay, right? So say a dispute arises in the internet marketplace. eBay is able to, through a third-party service provider, but you access it through the eBay site. So they have the third-party service provider enable people to very quickly and easily have negotiations back and forth to be able to try and reach a settlement in the first instance. And one of the reasons then you're dealing with sort of a facilitated settlement and negotiation procedure. And a lot of the ODR applications contemplate that you're trying to start with that sort of negotiation at the beginning. See if we don't need to have any formal procedures. Because you're sort of outside of the court system, and you're using a process that's a little bit more flexible, you always have compliance issues. And the reason why it works in a place like eBay is because someone doesn't want to be excluded from the virtual marketplace, right? Like there's a great incentive to use it. One of the things that we've seen in some of the other ODR platforms that have evolved recently. So Claros is a blockchain-based platform that's, in theory, you have a smart contract, and then you want to have a dispute resolved, on the blockchain. So what they do is they crowdsource jurors essentially to decide a dispute, and they incentivize the decision by giving tokens, and it's all a game theory mechanism. So the jurors get the evidence, they get information about what the dispute is, and then what they try and do is say, well, how's everybody else going to resolve this? And by how everybody else resolves it, then they get tokens. So in the case you sort of mentioned, if I'm having disputes with my banking provider, or with Robinhood, or whoever I'm dealing with my banking kind of services, the sort of compliance issue, I think you start to run up against a little bit, because the incentive structures are a little bit different, right? You're not going to crowdsource people to resolve that kind of dispute. The part that would still work really is the sort of settlement and mediation kind of piece of it. Whereas if you have a small value transaction, it's mostly, a dispute about whether you're going to, refund these transactions, for example, they, erroneously appeared on my account. You can have the back and forth to see if there's an agreement, on a settlement, right? So one of the ways that you can either have an automated ODR process, or you could have a third party intervene to sort of facilitate, right? Like a traditional kind of neutral. But some of the more successful sort of settlement apps that have developed, or online dispute resolution systems have involved, I make an offer, the other person makes a demand, and then there's sort of an algorithm to say, well, if they're within a certain range, like 30% of each other, or $1,000, then it settles. And if it doesn't, then you can have a negotiation. You don't know what the other person offered, so there's no prejudice, but you move into sort of a negotiation kind of phase. That's a system that has worked quite well and been adopted, in a lot of different instances. New York City, for example, used a system like that to resolve hordes and hordes of those sort of slip and fall kind of claims. The city controller was trying to deal with a lot of the small claim stuff, and we now have in New York an online dispute resolution, pilot program for small claims court disputes. So that kind of model, I think, Tundi, really is something that we've seen had a lot of success. And if you can, put that together, it makes sense. But you have to, if you don't have regulations for all of the providers and so on, then it's really a question of how developed the ODR platforms are and what kind of trust you have in the ODR, platforms that are available.
So thank you for those questions, Tunde and Stephanie, for doing justice to it. I did find the Claris model that you mentioned very interesting, and I'm sure we're going to see quite a few questions. I have a couple of questions already in my head around the enforceability of some of the decisions and a few other issues that, that could come out of some of the ODR models that you see some platforms adopting. But before I get to that point, I just wanted to ask a generalist question in terms of what do you see? I mean, some of the upsides are already clear, but this is a two-pronged question. So what are the upsides and what are the downsides to ODR, especially for, these fintech disputes that we're talking about?
Yeah, so I think the biggest is access to justice, and that I think speaks really to the point that Tundi was making about the extension of wireless networks in Africa, and the fact that people are able to access banking services in different ways. All of the extension of technology, whether it's the dispute resolution or the underlying service digitization of the economy, has really created access to so many things. So access to the justice piece of it is, I think, the sort of biggest upside on using ODR. Cost, obviously, if you, especially for low value sales or service contracts, it just doesn't justify having some of the in-person meetings and procedures. And that always ties in considerations of time as well. Any kind of geographic distance that's involved. And normally I think, we would talk in terms of cross-border when we're thinking about digitalization of the economy. But again, Africa, that's a big continent, right? So depending on where your transactions are taking place, even within a single country, right? People, providers, and so it's not necessarily so easy to meet for in-person court procedures if that would entail a significant distance in travel. So that's one element. But relatedly, if we go back to the cross-border piece, it's uncertainty about the legal framework. And that's one of the things that also ties in, if you're thinking about sort of traditional ODR versus traditional dispute resolution. If you're focused on flexibility of being able to move between negotiation, settlement, mediation, there's sort of some fluidity. You may not have, the New York Convention hiding in the background, but the idea is that you're able to have, a more flexible process. It's not tied up in rules of evidence and procedure, that type of model, right? Whereas if you move to sort of a more traditional framework and you are thinking about a process like the EBRAM model, where it's more going through a full kind of arbitration from start to finish online, that does entail familiarity with legal procedures. And so that has pluses and minuses. If we were talking about the kinds of cases I was talking about seeing in sort of, fintech, like the developer disputes or the fraud disputes, that's not so easy to just deal with on the, negotiation settlement piece necessarily. You may, really need to be getting into more of the nitty, the sort of the nitty gritty, having expert witnesses and having that kind of process. So I'd say a disadvantage, again, depending on where on the spectrum we're talking about ODR, but traditionally thinking of the sort of its origin, one of the disadvantages would be that, you're not really delving into the substantive merits of the case. So there's a plus to not having to confront some of the legal, and there's also, you know, a disadvantage depending on the nature of the dispute. The enforcement mechanism I mentioned. One other thing is if we're dealing with automated system, right? So I described the type of ODR, for example, where you get an offer, a demand, and then there's sort of an algorithm deciding whether it's close enough for there to be a settlement, or even in the, in other models where if you were to feed in facts, right, and talk about artificial intelligence being used to take certain facts being fed in, and then you're, reaching a decision about outcome. Well, there's a risk of bias in the system design, and that's a major, concern whenever you're talking about artificial intelligence applications, because they're all developed, by humans in the first instance. So I think when we're thinking about, the evolution of ODR and more sophisticated platforms, and thinking about, where we move from its origins, and perhaps trying to have more sophisticated versions for the more sophisticated type of disputes, there we might start to run into, more of those system design challenges, because you're sort of presented with new challenges, ones that hadn't been confronted by the more simple e-commerce, kind of straightforward dispute.
Thank you, Stephanie. But just sitting with the topic a little bit and expanding it a bit more, the question that I wanted to highlight is, how binding are these outcomes? So if parties have gone through this ODR process, how binding are the outcomes? And particularly like in cryptocurrency, and this is something that we're starting to see a lot more often, is that these disputes have an element of fraud, like you've said, or criminality, which typically need to go to the normal courts, to the fiscal courts to be determined. In fact, have to be prosecuted specifically, jurisdiction by jurisdiction, but have to be prosecuted specifically by the state. How does that play out generally in practice?
Well, I mean, it's going to depend on the ODR platform and the rules. I mean, if we were talking about EBRAM, which I have just mentioned, coming out of Hong Kong, which does have different processes, but again sort of contemplates more of the full scale traditional processes just brought fully online. The idea is that you could end up after an arbitration with a New York Convention award, right? So that's one example. But if we're talking about something like that eBay model, again, you don't have anything enforceable at the end of the day. You're counting on some sort of buy-in to the process that encourages compliance. So the example of eBay was that someone doesn't want to be excluded from the virtual marketplace. So they, are participating in this system, and they are going to abide by the decision because it makes sense for them to sort of resolve these, smaller disputes through this mechanism. And sometimes it's going to work for them, sometimes it doesn't. But if they don't abide by it, they're not going to be able to continue to be, a seller on the marketplace or be able to participate in the marketplace. If you were to do online, mediation, it's possible you could end up with a contract at the end, right? You could agree to a settlement, a settlement agreement. And again, depends, how sophisticated the mechanism is. If there's a third party neutral involved facilitating it, then you would, depending again on the rules, but I would have an expectation if there were a mediated settlement that you probably, you may very well end up with a contract at the end of the day where you have a settlement agreement, and then, you're dealing with that kind of, enforceability issues. So there's a spectrum, and it's going to depend.
Okay, great. So another thing that I'd like you to address is the security aspects of, the use of these electronic systems in ODR. So for instance, with the EBRAM model, where arbitration is happening for these disputes from start to finish, and this is a confidential process, but it's a confidential process that's happening online. So what what are the major challenges that you can see, as far as security is concerned when you're implementing the ODR model?
Yeah, so a couple of things. One is if we're talking about new platforms coming into existence, new sort of players, obviously the security, because you're online, as you've rightly noted, the integrity of the system really depends on the security. And that's true of anything that ends up being digitized these days, but you really have an ability for the whole thing to fall apart if you cannot, offer sort of the basic protection. So anybody who's entering this field or anybody who's in it, security has to be top of mind. And so, looking for, the sort of basics of things like encryption and access credentials being dealt with, two-factor authentication. Those are things that you would expect, to see really, dealt with by the platform provider. And, EBRAM, again, being an example, they seem to be quite focused on these issues. And that's a selling point for them to say, this is something that we recognize is integral to the success of the system. And so we are absolutely, it is top of mind for us. And you're trying to sell confidence and trust in the system as an ODR platform. And so if you haven't been attuned to that, that's obviously a major issue. I think one of the other things that is a sort of a sister of security, very closely related, is data protection. And that is, all the data protection regulations, how you're dealing with personal data is going to be at issue in a lot of the kind of disputes that we're talking about, and highly sensitive data. If we're talking about Tundi's financial, services issues, banking issues, it's people's bank accounts, right? That's very sensitive. And so personal data, we're seeing absolute proliferation of regulations around the globe. GDPR has really sort of been the driving kind of model. And so we all, sort of tend to look to that as sort of a, baseline kind of regulatory framework, because a number of jurisdictions have started to sort of model after that. And if they haven't, it's one of the toughest jurisdictions, right? Because it's a lot of sort of strict rules. So trying to navigate that is a massive issue, and it is because it's something that in recent years I'd say we've been aware of, but we're still not really on top of in terms of compliance and understanding how to deal with it. And there are emerging tools in the dispute resolution space. The ICA finally launched after many years of work, the ICA roadmap on data protection, with a lot of sort of resources in that, and the sister document, the ICA protocol on cybersecurity and international arbitration. Its attention to those issues is really going to be fundamental to whether you could sort of see ODR continue to develop, because the hacking that we have today is not the hacking that was there in the 1990s, right? Cybercrime is the #1 type of crime. So it's a very different challenge. It's a real challenge, but we're confronting it in all aspects of our, economy. So I think there's hope in that respect, because as the crime becomes more sophisticated, we have hopefully less of a disconnect between sort of engineers focused on functionality and practical sort of convenience, and security. Like, they just go more and more hand in hand. We haven't necessarily seen that in all of the tools that get developed. I think the emergence of more online case management platforms, again, in sort of traditional arbitration. I've seen regional centers coming up with new case management platforms, for example. They don't necessarily always adopt some of the baseline cybersecurity measures as default, things like two-factor authentication. You have to ask for it. And really, that kind of thing should just be a default measure. And it's because it's, it is sort of there may be more specific things you need to do depending on the nature of the information. We always want to be careful not to impose too many security measures that then make it so that people won't use it. But there is a baseline, and things like making sure that we're using strong passwords and two-factor authentication and appropriate encryption. Those, I think, are, you know, basic baseline measures that really have to be adopted if we're going to see this continue.
Great, thank you, Stephanie. And I like that you segued into the conversation about data privacy and the regulations that we have had in different jurisdictions around the protection of people's data. And it just brings me to the question about what do you think? Do you see any potential benefits with actually regulating ODR across jurisdictions? So should we be advocating for regulations for ODR in specific for each jurisdiction to legislate rules or guidelines to govern ODR, so that there's a baseline set of standard or a baseline set of rules to govern these procedures from platform to platform, so that it's not just a question of, you know, which platform are you doing this ODR on? Do you think that's something that, you know, we should be advocating for or looking at?
Can I tag on to a question to that?
Yeah.
Oh yeah, absolutely.
Yeah, can I tag on a question? And it goes to something previously you talked about, enforcement. When we talk about ODR, I suspect what we're also talking about is a lot of different types of ADR. And when we talk about ODR, which one is appropriate? And I think what you mentioned is akin to expert determination. My question is this: if we're going to regulate it, does that mean that the decisions which look more like expert determinations, because they're definitely not, they don't have the enforceability of awards, and they don't have the same impact as a negotiated or mediated agreement, but they are decisions which don't support, which don't have the support of the New York Convention? Will expert determination be the new award in ODR? That's my question. I
mean, it's a great question. I think to a certain extent, you know, Ngozi, your question is also a little bit philosophical. I mean, let's go back to where ODR started. And, you know, Tunde, you just described very well that it's, you know, at its core, ideas that you can have a more flexible process. You're not restricted by the sort of traditional legal framework, and that there can be some fluidity moving in between, right? If the sort of automated negotiation for acceptance doesn't work, then we can move to mediation. Or what if we have the more complicated dispute, like I mentioned, can we then move to expert determination? And I think some of the question on this is, what do people want, right? All of these systems really need to ultimately be driven not by those of us who decide the disputes, but those who have the disputes. And you know, financial industry has not done well with ADR arbitration outside of court settlements. We have not managed to attract that industry to our arbitration world. So
let us knowledge. Sorry to interrupt you. I'm going to do a little straw poll, because it's a knowledge interactive session, and I'm going to do a straw poll. Who thinks an expert award, an expert determination, should have the same effect as an award in ODR? Let's just a philosophical question, yes or no, and then we count it. Sorry to interrupt you. Go on. You can say yes or no in the comments, and then we'll have the answer. Please go on.
So we'll see what people put, what people
exactly.
put in the comments. But it does come back to the idea that enforceability isn't always the be all and end all. I mean, we sell international arbitration by saying, look, you know, you get the currency of an enforceable New York Convention award. But the sales pitch for ODR and from its origins is not on getting an enforceable award or enforceable decision. It was in being able to come to something that you can live with in a shorter term, right? Like if you make the offer and the acceptance and the idea is that the algorithm says you're close enough that we're going to just settle it, you didn't get exactly what you wanted, right? But it's getting out of the adversarial system. It's doing something in a more consensual fashion. And if the reasons why we have not been popular with fintech is because it's too expensive, it takes too much time, and we need to keep developing our technology and move on, or we really just have a lot of low value, high volume kind of repetitive type disputes, then they're not looking for the same things in terms of outcome of the process. And so we probably just constantly need to do a better job of thinking about, what is it that the people who have the disputes using, be a client-driven system. And I do think that there's greater scope for negotiation and mediation in some of the sort of software collaboration kind of disputes that I mentioned. I know from personal experience, I have some small, my husband has some small businesses. We've had software development, worked on software development stuff, and you pour tons of money into it. Doesn't necessarily come out the way that you want, but the way that those disputes end up coming out is you can look at what the contract says and you can debate about time and services versus fixed costs and what was the scope of work and what was the quality of the work done, but it's not worth it. Because you have to get into too much of the sort of nitty gritty. So in that kind of circumstance, and there are lots of those kinds of disputes that arise in the fintech industry, particularly when we're talking about trying to develop, new applications from things like blockchain, cryptocurrency, because there are a lot of new kinds of distributed ledger technology. We're seeing, a lot of development in that respect. You need to do it fast, you need to do it cheaply. And so really have we been targeting that industry in the way that we should?
Thank you. Thank you, Stephanie. So in my mind, I'm convinced that at least as far as Africa is concerned, we need to see more ODR happening in the fintech space. But I just want to direct a question to you about what jurisdictions you think this ODR model has really taken off. And you've given us a few examples already. And how has this contributed to the ease of doing business in these jurisdictions?
Well, I mean, most of the original sort of ODR development originated in the United States and Canada. And so, that was really sort of more developed economies. But, there are a number of African cities that are in the top 100 sort of fintech markets globally. So if we're talking about opportunities and we think there's a synergy between fintech and ODR, I think some of the more developing areas, India as well, where we've seen proliferation of wireless communication, where that really is, much more of the sort of mode of living. People don't necessarily have computers, but they do have wireless telephones, and they have the big wireless telephones, right? That almost look like the giant tablets, because people are doing everything on those devices. Any jurisdiction where we continue to kind of see that, I think is ripe for seeing more of the sort of ODR. And that's because if we're coming back to sort of the more basic e-commerce kind of dispute resolution, it just doesn't make sense to sort of be doing things, in the traditional fashion. So I think that the initiative of, I've mentioned it a number of times, EBRAM, they don't pay me, I don't have any kind of special link with them, but I do find it a really interesting initiative because they have, they're trying to market, for example, dealing with disputes coming out of COVID, and really trying to make a push in not just Hong Kong, but sort of Asian countries where there's obviously been tremendous digitization of the economy, but trying to take advantage of something there and to sort of be seen as this new platform, something that is really trying to sort of merge what is happening in the economy and saying we want to do something that's not traditional, but that has some familiarity with it. The other area where I think I've made some mention of sort of court connected ODR systems. And I think there are examples where that has been tremendously successful. And that is something that I think, especially coming out of the COVID-19 pandemic and more courts from around the world having had favorable experiences, not universally, there's still many connectivity and access to justice issues when dealing with sort of, more cumbersome infrastructure. But the idea that you could potentially resolve a dispute with nothing more than your telephone and a cellular connection is really attractive. And especially, if you have to go through a court system, I think the kind of program that New York has, for example, saying, look, in small claims court, if you're under $10,000, if it's for sale of a service, sale of goods or for a service, and you're not represented by attorneys, we'll refer you to the ODR service, see if you can negotiate a settlement. If you can't, we'll give you, free mediation. And if that doesn't work, then you come back to the court system. That I think is a really attractive model. And it's something that it would be, terrific if we sort of saw more of that. And Ngozi, you had asked a little bit about regulation, and I kind of sidestepped a little bit. And I said, let me come back. I think traditionally what we've sort of seen is, on that sort of philosophical question is because of the fluidity, the emphasis in a lot of the literature, and this is the kind of thing, Mirez may have thoughts about, but was that it really is more about self-regulation, because you weren't trying to fit within the sort of traditional legal framework. You wanted to have the flexibility, but really important to have guidelines. So, UNCITRAL between, I think, like 2010 and 2016 had, working groups that were dealing with ODR, and a guidance note for ODR platforms kind of emerged from that, emphasizing fundamental principles like transparency and fairness and independence. And, that kind of initiative remains at the sort of, top and the forefront. We certainly need that kind of guidance, and you need ODR platforms to adhere to those kinds of fundamental principles. That the American Bar Association, after many years of study, also recently, released a similar type of guidance note on, having looked again more closely at what kind of ODR platforms are out there. What are the sort of guiding principles that need to be addressed? And it doesn't really advocate for more legal regulation of ODR platforms. What it advocates for is respect for the sort of basic kind of principles. It does say, you need to adhere to any laws that might govern the particular platform locally or what have you. But I think the emphasis, because of the fluidity of ODR and the idea that you're sort of able to take advantage of, in many of the systems, sort of multiple processes, starting with, conciliation, facilitated settlement, moving to mediation if you need to be, that the regulation of it becomes much more difficult and would almost be stifling. But you still have a lot of these other issues that we've talked about, like data protection, so where there are regulations of a different kind of nature that obviously impact on it. So do you need to regulate it? Not as long as people adhere to the basic principles. So, we haven't exactly seen proliferation of ODR platforms in the way that there are ones that have sort of made a lot of news about being especially problematic. I mean, I'm not so sure Claros, I want to, be putting my kind of dispute to sort of crowdsource justice, but that's a different kind of issue than one that requires regulation. If you have consent, that does a lot. You just want to make sure that you don't have platforms taking advantage of vulnerable people as well in sort of a quest to have access to justice. So others might have comments from experience on that, but I think that's sort of my take on some of the regulation.
Yeah, I just wanted to highlight as well for those that weren't looking at the charts that the guidelines that currently exist that govern ODR that were provided by the International Council for Online Dispute Resolution is there as well. And there's a link in the chat box basically pointing to where you can find those guidelines. I can see Mirez has a hand up. Mirez, please.
I just wanted to point out that the person who built, Stephanie, you may know that the person who built the system for the New York court and the person who chaired our work with the ABA dispute resolution section is David Larson, who's also a fellow. So, and I wanted to make also a comment. I agree, Stephanie, that actually in the fintech, it has so far not been so successful to use ODR and what do people need. But I guess, and this was always something that I've been militating for, is that if I don't have a product to offer to users, users may potentially not think about it, but I need to hear the users, provide a product, and then try to disseminate the information and educate the people to use it. That has been extremely difficult because it's true that dissemination and education of users has not been enough focused on. So we need to work a lot on that, but try also to offer products and certainly not interrupt them once we have launched them, because this is the worst ever mistake that many have done. Instead of upgrading a system, thinking that it's not good enough, we just stop it and may think about something else. It's energy, time, and money wasted for nothing. So that was one of the reasons for which many platforms had unfortunately to stop. Just a comment.
Yeah, I mean, I think that is, our desires for what technology can do often doesn't meet what then gets built, right? It takes time to build platforms. And there are, a lot of fine details when you're coding that lead to errors. And you often have, engineers who are trying to listen to what the sort of end user is describing, but are not immersed in that field, right? And so that's certainly in legal tech. If you have engineers developing something for legal uses and they don't have the sort of legal understanding, there can be a disconnect in that communication. So we see that in lots of different platforms, not just sort of online dispute resolution, but online case management platforms in, so often what gets produced at the beginning is kind of down here. We want it up here, and we say, like, these are all of our needs, and we want a system that does all of these things. And then you get the engineers, and first you get this, and you're like, oh, it's not that great, but it's hard to take that first step and say, like, let's just get that, and then we can upgrade. As you say, Mirez, I mean, it's not perfect, but that's often the situation that we find ourselves in. One of the things, I was just in Canada last weekend for ICC Canada, and we had a bit of a roundtable discussion about uses of technology now, and how counsel and arbitrators feel as they are able to do things in person again. And with the ICC Commission report that we did on leveraging technology, when we surveyed people, we found that there was great willingness for people to use technology more than they had in the past. And they said, yes, we're much more willing to do paperless hearings. We're much more willing to use online case management platforms and so on. Well, I went to this ICC Canada meeting. We had this roundtable, and some of the counsel said, well, yes, I like to use some of these things, but here are the difficulties in my law firm, because they'll only let me use, this kind of system and not my tablet. There are these security problems. So then I can only do it from access from the cloud, but that's a problem when I'm in a proceeding. I need to have the files locally so that I, have the confidence when I'm showing documents. So again, disconnect between trying to implement and operate. So, some willingness to leverage technology, difficulties on the ground because of the practical in leveraging it, and that is holding us back. And so then I just heard, we want to do things in person. So are we going to, lose the momentum where we really started to move forward and be able to do a lot of more things online? I have a bit of a concern on that respect. I think we still, are going to cling and better incorporate, and we still are better incorporating some things like virtual hearings, but it may not go as far as it should because of those kinds of issues. So we're sort of at an exciting moment, but also a challenging one at the same time to see how we are going to continue to sort of adopt technology and leverage it, in this digitized economy.
Thank
But
you.
I
Thank you
think
very
on
much.
the fact that we don't have the same language. I mean, the engineers speak one language and we speak another one. It's always difficult to agree. Thank you, Stephanie.
I just wanted to point to our poll, Stephanie.
Yes,
And
yes.
how inconclusive it is. If I look at it, it's even far more baffling to me than to interpret that. There's enough data in that to actually have me worried. But thank you very much for everyone that participated in that poll. That's actually to hear that it depends. And I think that's what Stephanie was saying, that buy-in and acceptance will be key as to the new development and how these systems will change our perception of what decisions, I wanted to say binding decision, of what decisions will be acceptable and how even the courts in various jurisdictions will accept that, because that goes towards the regulation question as well of whether these things will be seen as extrajudicial but not in arbitration, and whether public policy in those jurisdictions will sort of bend that way. That's it's one thing for us lawyers and business people to want something. It's another thing for perception of the users, and we're talking about lay people, to accept this willingly. And the other thing I wanted to mention is, please mention Ibram. Puki was here with us about a month ago. And we quite like her here and the ideas that she represents, given that at least she's an ex-colleague of myself and Mirez, and we quite admire the work she's doing to introduce new things across the group. So please mention Ibram as much as you want.
Thank you. Thank you so much, Stephanie, for spending this time with us and, for sharing your knowledge. Thank you for your contributions today. Thank you, Mirez. This has been a very insightful session. Thank you to everyone that has stayed with us to the end and who voted in the polls. Our time we're already outside of time. So thank you to everybody for participating. Have a very good evening.
Before you go, I would like one of our board members, Andre, to do a vote of thanks. Mirez wanted to say something as well, to say a vote of thanks. Andre, do you want to say a vote of thanks for everyone before you go? You've not said anything. Yeah. You're muted still.
Yes.
Okay.
Well, even though I joined slightly late, and even though I'm probably one of the generation which doesn't understand a great deal of all the artificial intelligence and the debates around it, the one thing that we're aware of is that the world is changing, the methods of communication are changing, and law is changing. Law is changing for a whole lot of reasons. The one is that we're supposed to kind of reflect the society around us, and that's got all these new gizmos, which I don't even pretend to understand half of them. But the other is this, and I think that's perhaps the encouraging part, is to take away that there are systems. Personally, I don't believe that they'll ever do away with the human element completely, except in, the very much routine eBay type of situation where you've got 200,000 disputes a month. the complicated disputes, we're still going to need human beings, but what is encouraging is even those, hopefully, as we start understanding and applying the tools, it'll speed up the process and make it more cheaper. If it can do that, then firstly, everything that you've told us tonight is going to be of long-term value, and all the work that ODR Africa is doing, same applies to. So thank you very much for your time. And I suppose I could also say thank you for keeping the language of such a nature that even us that were born in the previous century and struggled to keep up with much of the techno-speak could follow what you're doing. Thank you very much.
Thank you.
Thank you, Andre. Mirez, did you want to say something as well?
No, I just wanted to say that was an excellent presentation. Thank you, Stephanie, and an excellent overview of what existed, what exists, and the wish list. Hopefully that we can get to it one day. Thank you, Stephanie.
Thank you.
Thank you again, Stephanie. And Ngozi, yep, you have the final word.
Yes, so thank you everyone for joining. Thank you to ODR for putting the ODR Africa Network for putting this session together. Thank you again, listeners, for letting us take a bit more of your time than we anticipated, and have an amazing evening, everybody.
Thank you.
Thank you, everyone.